Good morning to all of you. Welcome to Legal Matters by Sai Babu Sankara. Jurisprudence class. In this video, we are going to discuss the concept of reasonableness. Law should be reasonable. Whenever the legislature makes an act, it should be reasonable, should be rational, should not be irrational. If it is not reasonable, it will be struck down by the court as void or unconstitutional or things like that. So, to understand the concept, we are going to discuss maybe 4 or 5 important case laws. These are all landmark judgments which were given way back from 1954 onwards. You may feel frustrated because of the old age judgments, but please remember they are the most important judgments which have got the value of the precedent, PRECEDENT. Therefore, of course, they are also in the syllabus, so you have to read them. Today we are going to discuss the first case law on the test of reasonableness. That is State of Madras versus V.G. Rao, 1952. V.G. Rao, R.O.W. Rao. Of course, you can mention your name or you can write your name any way you like. We can't help. So V.G. Rao. Normally here we write Rao as R.A.O. but he has mentioned as V.G. R.O.W. V.G. Rao, 1952. Here, test of reasonableness is highly discussed in this particular topic. Actually, the state of Madras, they have, by statute, they have banned an organization called as the Communist Party of India. In 1949, they banned the political party, stating that it is anti-public or it is a threat to the sovereignty and integrity of the state. So they have banned the organization. Now CPI is banned, but at the same time they are continuing their activities in the name of some societies, in the name of their associates, or in the name of their persons, the organizations affiliated to them. For example, number of communist associations will be there. For example, if you ban the CPI, what happens? The AITUC, the teachers wing, they will come into picture. Likewise, the organizations, they are also propagating the so-called communist philosophy. The government came to know, State of Madras came to know that one such institution by name People's Education Society is propagating the communist ideology. It is publicizing the communist ideology, and the funds to the communists are being passing through the secretary, Mr. V.G. Rao. Right? So now they came to know that after the ban of the CPI in 1949, these people are continuing in the name of People's Education Society. Right? Okay. Now, during the year 1950, on 10/3/1950, the state of Madras, they declared People's Education Society also, please remember, as unlawful because of the allegations that it was assisting Communist Party, which was banned in 1949 itself. Right? So therefore, V.G. Rao, who is the secretary or the president of the so-called People's Education Society, he contested the matter and he filed a writ petition against the state, alleging that it is violative of Article 19(1)(c), I think, of the Constitution of India, that is forming of association. Article 19, right to form associations. So actually, it has been filed in the High Court and the matter is to be decided on 21/8/1950. But you see what happened. On 12/8/1950, so just 1 week prior to that, the state brought an amendment. You know, the legislature can bring any amendments, any laws. So they brought an amendment And as per section 15 clause 2, please remember 15 clause 2 clause B of the Criminal Law Amendment Act 1908. So it declared, the state declared that the People's Educational Society or such association is unlawful. The grounds are, it is causing danger to the public peace. Very important aspect. It is causing danger to the public peace. So it interferes with the maintenance of the so-called public order. I studied in the class, I told you the difference between general, main law and order and public order also. So now the issue came before the court is whether the section 15 clause 2 clause B of the Criminal Law Amendment Act 1908 falls within the ambit of section article 19 1C of the Constitution of India, or whether it is against the spirit of the Constitution. So here the important point is, even though the state of Madras banned the People's Education Society, no order was sent to the respondent, that is Education Society. V.G. Rao was not at all served with the order of the society. Of course, it is only published in the official gazette. So actually the government stated that when once it is published in the official gazette, the public are expected to know. So it means wide publication. But Supreme Court held that, please remember, held that there is nothing wrong in the state making any amendment, because on the grounds of public order, on the grounds of violation of the public peace or maintenance of the public order, definitely they can make the law. But the problem is, it has to be served on the opposite party, particularly when you are banning such an organization. Definitely you have to make a public notice that is going to be banned. You should give reasonable opportunity. Without the same simply saying that we have filed it in the official gazette, it's not a correct procedure. So please remember, and that too, this amendment falls outside the restrictions of the so-called 19(1)(c). That means there is no reasonability in giving such order without by conducting any inquiry. So please remember, it is unconstitutional, it is void. So please remember, even though the state of, actually the High Court itself stated that since you have not served the other people with a copy of the order, it's unconstitutional, they already said. But against the order of the High Court, these people came to the Supreme Court. Supreme Court also said that the judgment given by the High Court is 100% valid. Therefore, the appeal is dismissed. So ఈ కేసులో ముఖ్యమైన పాత్ర ఏంటి? ఒక ఇన్స్టిట్యూషన్ని, పీపుల్స్ ఎడ్యుకేషన్ సొసైటీ అనే దాన్ని అన్కాన్స్టిట్యూషనల్ అని మీరు బ్యాన్ చేసేటప్పుడు వాళ్ళకి నోటీస్ ఇవ్వాలి, వాళ్ళకి తెలియచేయాలి. సింపుల్గా మేము గజెట్ నోటిఫికేషన్ ఇచ్చాము, గజెట్ నోటిఫికేషన్ ఇస్ ద పబ్లిక్ నోటిఫికేషన్ అంటే కుదరదు అని చెప్పి, ఇట్ ఈస్ హెల్డ్ టు బి, దెర్ ఇస్ నో రీజనబుల్నెస్ ఇన్ డిక్లేరింగ్ సో అండ్ సో యాజ్ unbanned organization. This is the important point in this case. So jurisprudence law గుర్తుపెట్టుకోవాల్సింది, everything should be reasonable, law should be reasonable. If it is not reasonable, definitely it becomes void as stated in the particular case. So please read the case law and enrich your legal knowledge. With this I am concluding. Thank you very much.